Hello, everyone. Um, how are you all doing? Welcome to the Tort Law and Public International Law session for today. I'm the president of CSP, so yeah, I will be teaching tort law. Hope you guys enjoy. So yeah, so the way I'll be teaching this time, I'll just be going through the sections which are relevant in tort. These sections do not include undue enrichment or management of mandate without management of affairs without mandate. So just to be clear, like if you want to look at those two specific types or specific tropes in tort law, you can just refer to the notes that we have provided in our CSP drive. All right, so let's start. So when we start looking at tort law in Thailand, the first section that we have to look at is Section 420. Section 420 reads that a person who willfully or negligently, unlawfully injures the life, body, health, liberty, property, or any other rights of another person is said to commit a wrongful act and is bound to make compensation therefore. This is the most essential of all tort law sections, and most of the other sections, when we're dealing with guilt, rely on this section. And this section also adjudges that someone who commits a tort has to pay compensation. So the first thing I want you guys to know about is we have to know about elements, right? So whenever there's a section in Thai law, we have to look at the elements because for someone to be adjudged as guilty in a section or needing to pay compensation, they need to fulfill all the elements in that section. So for section 420, the first part is a person, right? So this is the person who's causing injury to another person. Now, in this case, it can be both a juristic person or a natural person, meaning it can be both companies or any person like you and me. And the second part is willfully or negligently, right? So willfully would mean that they have a will or they have the intention to commit the crime in question, whereas negligently is they're doing so without proper care. So there's many Supreme Court decisions about negligence, and it's pretty clear that all the Supreme Court decisions have ruled that when it comes to negligent, it means that someone didn't take proper care, or in this situation, they could have done more to prevent the injury from happening. All right. The third part is injures, right? So this means you cause an injury, which means you cause something bad to happen, or you cause basically you injure someone, and the injury could be to life, body, health, liberty, property, or any other rights of another person, right? So in this case, it could be to life, which is like your body, like for example, I kill you, your health, which is like maybe like radiation, or you burn something and you cause someone to have damage to their health, or it could be something to do with property, which is like you took someone's property or you borrowed someone's property and you broke it. So all of these fall into the category of injuring. And if they fulfill all these three categories, they are said to commit a wrongful act. So they are said to commit a tort. And in this section, they are bound to pay compensation for the tort they have committed. So, as you know, for section 421 to section 424, you have already been taught in the midterms, so I will skip that and I will go to section 425. So in section 425, it reads, an employer is jointly liable with his employee for the consequences of a wrongful act committed by such employee in the course of his employment. So in this section, what it essentially means is that the employer shall be jointly liable for the wrongful acts of his employee in his employment. For example, The clear example would be a truck driver who's driving on behalf of the company, delivering company goods, crashes into another truck driver. Now, this would be a tort under Section 420, and in this case, the injured party could claim recourse. No, sorry, could claim compensation from either the company or the worker or both. And in this case, we can see that Section 425, it reads that the employee has to be in the course of his employment. So the Supreme Court has decided on this case, and there are two aspects here. So first is we have to look at the time. So did the employee commit the wrongful act in the time of his work? Meaning, did he do it in the time specified in his contract of work? If so, then it would fall under the section, and it would mean that he committed a tort. The second part, we have to look at the scope. So in this case, we have to see if the scope is in the company's scope where they hired this employee. For example, if the truck driver during his break in employee time, which means the time when he's employed, decided to go slash someone. In this case, the employer would not be liable with the employee because this is not in the scope of the work where he was hired to do so. So basically, in this section, it has to fulfill two aspects to be wrongful under this section, which is that the employee has to commit it during the time of work and also has to do so in the scope of work as well. All right. The next section is Section 426. This section is related to Section 425, and it reads that the employer who has made compensation to a third person for a wrongful act committed by his employee is entitled to reimbursement from such employee. This section essentially just means that an employer in Section 425 who has paid on behalf of the employee can get reimbursement back from the employee. This is similar to Section 76 of the Thai Civil and Commercial Code, where the law allows the employer to get recourse from the employee for the actions on behalf of on the actions that the employer has to pay to the third person on behalf of the employee. So, for example, let's use the truck driver example again. So, for example, if the truck driver hits someone during the course of his employment, and the injured party demands compensation from the employer has paid the full compensation to the third person. In this case, the employer has the rights to claim recourse from the employee for the money the employer has paid to the third person. Now let's look at Section 427. Section 427 also relates to Section 425 and Section 426, and it reads that the two foregoing sections shall apply mutantis mutandis to principal and agent. This section essentially states that joint liability and also recourse against agents from its principals is the same as that of an employer and employee. As for example, in this case, if the agent commits a crime, commits a wrongful act, and in this case the third person demands the money from the principal, then the principal has the right of recourse under Section 427 to claim back from the agent. Now next, let's look at Section 428. Section 428 reads that an employer is not liable for damage done by the contractor to a third person in the course of work unless the employer was at fault in regards to the words ordered or to his instructions or to the selection of the contractor. This section essentially is an exception to Section 425, where the employer is not liable for the damage done by the contractor in some instances, right? So this instance would have to be that the work done by the contractor is in the course of work, it happened to third persons. And the most important part to negate the liability of the employer was that the employer did not order the work which caused the damage to happen specifically, or he was not negligent in his selection of the contractors. So in this case, it's quite clear. It essentially means that for the employer not to be liable with the contractor in this section to the third party, he must have no involvement at all. For example, if I was an employee and if I was an employer and I hired a contractor to build a building, and the contractor thought it would be funny to build something out of the building, right? For example, he built like extended more outside of the building, but I didn't order him to do so, and that building collapsed onto a third person. I would not be liable because it wasn't my instruction. But in the second clause, for example, if I knew that this contractor was really dodgy and every project they have done has caused issues, and they have done work very badly, and I decide to select them still, then in this case I would also be liable because it's my negligence that I selected the contractor that is known to be dodgy or to be like a bad contractor. Now, section 429, these are pretty interesting. It moves on to talk about the liability between incapacitated people and unsound people, including minors, towards the parents or guardians, right? So section 429 reads that a person, even though incapacitated on the account of minority or unsoundness of mind, is liable for the consequences of his wrongful act. This means that in this case, any person, regardless if they're a minor, if they're unsound, if they're incapacitated, if they commit a wrongful act, they will have to pay or provide compensation for the wrongful act. They cannot use an excuse, which we see a lot of times maybe in contract law, where they have excuse of being a minor and they can void a contract or something like that. But in torts, minors will have to have full responsibility for their actions, and they cannot use the fact that they're a minor or unsound to negate their having to pay compensation. And in this case, the parents or guardians of such person is liable with him unless they can prove that they perform proper care. So essentially, it gives an assumption that if the minor did something wrong, the parents would automatically have to be liable unless they can bring evidence or they can prove that they, essentially performed their duty or has taken the best care possible. So this is very subjective on like what the best care is, but there are some instances that I will show you later that makes it much clearer to everyone to see that like what it means. So in section 429, to give a clearer example, I will use this example. B is a minor who was recently expelled from school, right? A is the father of B and knows that B has violent tendencies and tends to physically assault his peers, right? So B is a minor, but he's a very violent kid. Maybe he has some problems and, he likes to assault people or he has anger issues. And then A then sent B to another school where he again physically assaulted someone, right? In this case, A will also be liable with B because he already knew that B has tendencies to cause problems or he has tendencies to physically assault someone. So in this case, we can say that A did not assume the best care he could for B. He breached his duty and he has to be liable with B. But for example, if A in this case sent B to school and B has never had any problems, he was never expelled, and he didn't have any physical tendencies, in this case, he would not be liable because he assumed his best care possible, and it just happens that that B just had violent tendencies at that moment. So A would not be liable as well. This is a very clear case. I would say most cases that the Ajahn will give you in the exams will be much more debatable. And I think that in this type of scenario, you can debate it either way. It doesn't mean that, you have to debate it one way, or the professors will only give marks for one way. I think that if you have your reasons to back up your claims, and you can debate this either way, and usually it's very debatable. Now let's look at section 430. This is very similar to section 429. And section 430, it essentially talks about teachers, employers, or other persons who undertakes supervision of an incapacitated person, either permanently or temporarily, is jointly liable with such person for the wrongful act committed by the latter whilst under his supervision, provided that it can be proved that he has not exercised proper care. So this is very similar to the sections before that we can see. It essentially just says that if someone's an incapacitated person, right, and they have a guardian, and that guardian may be a teacher, an employer, or any other person, they are jointly liable with that person whilst under his supervision, unless he has already exercised proper care. So in this case, it would be something along the lines of, say, for example, you were admitted for a mental illness in a hospital, and they assign that a nurse has to take care of you. And this nurse, has to check in every 15 to 20 minutes, but they neglect their duty and they check in once or twice a day. And you left the hospital and you decided to cause some injury to someone, then in this case, the nurse would have to be liable with you as well, because under their supervision, they didn't exercise the proper care that they should have. But if they visited you as in their schedule, as they should, and you still cause injury to someone else's property, so in this case, they would have a point to neglect their liability, and the only person who would be liable would be the person who caused the injury, not the person who's a supervisor. And this is same with the teacher as well. So essentially, it's any position where an incapacitated person is taken care of by someone of a higher status, and they basically neglect their duty. But I would say section 428 and section 429 and section 430 are very, very similar, and essentially talks about the same things. Now, under section 431, it says that in the case falling under the two foregoing sections, the provisions of section 426 shall apply mutandis mutandis. So this is exactly the same. It just allows parents or teachers to get reimbursement for being the joint debtor with their children. It's really funny, to be completely honest, because in this case, it's essentially saying that the parents has the right to gain recourse from their children. So for example, if their children misbehaves and they have to pay, they can ask for the children's property back later on. It's really weird, and it when we talk about it, it's kind of funny to us, but this is what the law allows. But usually I would say that it's rarely enforced, because no parent would usually get money from the incompetent child or any other person. So it's very, very rarely used, but it's one of the options which the law allows. Now let's look at section 432. So in section 432, this section talks about joint debtors. It reads that if several persons by a joint wrongful act causes damage to another person, they are jointly bound to make compensation for the damage. The same applies if, among several joint doers of an act, the one who caused the most damage cannot be ascertained. Person who instigate or assist in a wrongful act are deemed to be joint actors. As between themselves, the person jointly bound to make compensation are liable in equal shares under the circumstances the court otherwise decides. So essentially for this clause, it states that those who commit an act has to be jointly liable for compensation. If they are deemed to be jointly liable, they would also have to pay in equal proportions. And yeah, so essentially in this case, it talks about a tort or a wrongful act where there are many doers or many persons who jointly committed a wrongful act. For example, if Mr. A, Mr. B, and Mr. C decided it would be funny to go smash up someone's car, right? And they all do it, then they would all be liable, and they would all be liable in equal amounts. Unless, for example, Mr. B, Mr. A hit the car only once, and Mr. C hit the car like maybe 200 times, and he caused most of the damage. Well, in that case, you might be able to bring a case under under part 3 of this section to the court and have the court adjudge that Mr. C would have to pay more than Mr. A and Mr. B because he caused most of the damage. But in a general case, it would be that they would all have to be liable for the same amount if they are all jointly liable, or if they are all jointly committed an act. So in this case, it just talks about joint people who jointly do a wrongful act. One second. The next part is section 433, and this talks about damage caused by animals. It reads that if damage is caused by an animal, the owner or the person who undertakes to keep the animal on behalf of the owner is bound to compensate the injured party for any damage arising therefrom, unless he can prove that he has exercised proper care in keeping it according to the species and natures or other circumstances, or that the damage would have occasioned notwithstanding the exercise of such care. The person responsible under the foregoing paragraph may exercise a right of recourse against the person who has wrongfully excited or provoked the animal, or against the owner of another animal which has caused the incitement or provocation. In this case, it just essentially states that the owner or the person who is currently taking care of the animal will be liable if the animal causes damage, unless he has taken proper care similar to with parents, child's guardians, and incompetents. This is very similar to section 428, 429, and 430, where it essentially allows or assumes responsibility unless they can prove that they have properly taken care of the situation. However, in this case, it's quite special because it says that if the animal has been provoked or excited, the person in paragraph 1 can claim recourse for compensation from the person who provoked such animal. So, for example, if I was walking a dog in the park and someone came to provoke my dog and my dog went to bite another person, right? So my dog caused damage to another person and I will have to pay to that other person the damages, but I could claim the money back from the person who provoked my dog. So essentially, it allows for the injured party, to claim compensation from the person who's the owner or the person who's taking care of the animal at that time, but it allows for recourse from the person who has to pay compensation from the person who provoked the animal, if there is any. If there isn't, then they cannot claim from anyone and they will still have to pay. Now let's look at section 434. Now this section essentially talks about defective construction or inefficient maintenance, right? It reads that if damage is caused by reason of the defective construction or insufficient maintenance of a building or other structure, the possessor of such building or structure is bound to make compensation. But if the possessor has used proper care to prevent the happening of the damage, the owner is bound to make compensation. The provisions of the foregoing paragraphs apply correspondingly to defects in the planting or propping of trees or bamboos. In the case of the foregoing 2 paragraphs, there is also some other person who is responsible for the cause of the damage. The possessor or the owner may exercise a right of recourse against such person. Basically, this section just essentially states that if a building or structure causes damage due to maintenance or constructural issues, the possessor will be liable, right? The owner will not be liable. But if proper care is taken on the part of the possessor, then the owner will have to make compensation instead. So this has split liability, right? You can see that in the first part, if the structure is due to poor maintenance or construction issues, the possessor will be liable. But if proper care is taken, then the owner will have to make compensation instead. Now, in this case, it's sometimes could be hard to ascertain. And if you cannot ascertain who is the person, or if you cannot ascertain if proper care is taken, then in this case, the law will have to assume that the owner will have to be liable. Because in this case, the law automatically usually assumes that the owner of the property is more liable than the person who is the possessor. But this has conflicting Supreme Court decisions. So you have to use the Supreme Court decisions which the Ajahn has provided in the slides. And under paragraph 3, if there is another person who caused the damage, then both the owner and the possessor could claim recourse from that person. So, for example, in this case, if you have a building, and the building essentially has a flaw in the construction, but the flaw is not in the possessor's fault, and he has exercised proper care, but it's the defect from the person who was the constructor of the building originally, and the building has a problem, and maybe it caused damage to someone. In this case, the person who would have to be liable would have to be the constructor. And which section do we use? We have to use section 434, part 3, because it says that if another person is responsible for the cause of the damage, the possessor or the owner may exercise the right of recourse. So in this case, the possessor or the owner will have to pay to the injured party first, but he could claim the right of recourse from the constructor later. Now let's move to section 435. In this section, it reads, a person who is threatened with an injury from a building or another structure belonging to another is entitled to require the latter to make necessary measures for averting the danger. This section essentially allows a person who's threatened with an injury from a building or other structure to make measures to avert the danger. To avert the danger in this case means you will have to petition the court for an order to do so. You cannot just avert the danger yourself, or you cannot just take actions yourself, but you have to file a petition to the court to do so. The important part is that in this section, the person who is injured only has to be threatened, but damage did not happen yet. If damage has already happened, you will not use section 435, but you will have to go and use section 420 instead. Because in this case, it deals with a person who is threatened with an injury, not a person who has been injured. This is very important, and a lot of people get this wrong. So I think in the exams, make sure you remember this, a very important concept, because this section always comes out in the exam a lot of times, and the professor is very strict on this. Now, this is another very interesting section, section 436. It reads that an occupier of a building is responsible for damage arising from things which fall from it or are thrown in an improper place. This section is actually really, really tricky, and it's really, really hard. This is because the word occupier in this section is very subjective, and a lot of people who read this section without looking at the relevant Supreme Court decisions will not understand. So in this section, when it says occupier, it means the person who's currently possessing the building. An example is A owns a room in a high-rise condo. So imagine a high-rise condo, and there's a room, right? And A owns the room. A invites B over, right? So B and A, both of them are in the room. B comes over and throws a glass bottle out of the room and hits C. C is a garbage collector in the area. So imagine you throw a glass bottle from a high-rise condo and it hits someone below, right? C was severely injured. In this case, A would also be responsible in this section, but B would be responsible under section 420. This is because A has a duty under section 436 to be responsible for the damage arising from things which fall from his building. So he would be liable under this section because he will be liable for every single thing or every single damage that occurs in a falling motion from his room, even if he wasn't the one committing the act. So in this case, A would be liable under this section, and B would be liable under section 420, because B in this case is not an occupier of the room, but he's just a visitor. This is very important, and I feel like this section is very hard, and it's very heated when it's debated. So yeah, please remember this, because this is proven by the Supreme Court decision to be the way they judge and the way they basically interpret this section. Section 437 is also another section which is quite tricky. It reads that a person is responsible for an injury caused by any conveyance propelled by mechanism which is in his possession or control unless he proves that the injury results from force majeure or fault of the injured person. The same applies to the person who has in his possession things dangerous by nature of destination or on the account of their mechanical action. In this case, it is also quite tricky. Basically, this section is mostly used for cars and motorbikes. It's essentially when a car crashes into another person, because in this case, if a car crashes into another person, it would fall under section 437 because a car is a vehicle which is propelled by mechanism and is in someone's control. But if a car crashes into a car, surprisingly, this would not fall under section 437 and it would fall under section 420. And this is basically a ruling from the Supreme Court, which has ruled in this in the past. And the professor has also adhered to this ruling. To be fair, it's quite debatable and no one really knows why this is the case. But you have to remember that if a car crashes into another car, this would fall under section 420. But if a car crashes into any other things, which is not a vehicle propelled by mechanism, for example, if a car crashes into a building, crashes into a person, causes damage somehow, this would fall under 437. Also, if a car crashes into a motorbike, this would not fall under section 437, but would fall under section 420. Also, the second part of this, the second part of this question is things which are dangerous by nature or destination. So, for example, this could be something of like maybe a metal chainsaw. If you have a metal chainsaw in the car, and basically, it was your fault and you accidentally left it open and it slashed someone's hand, that would be 437 because things like that are dangerous by nature. Or for example, this would apply to things like guns as well, because guns would also apply to this section. So for example, if you drop your gun in public and it accidentally shoots at someone, you would also be liable under section 437 paragraph 2 because these are things which are dangerous by nature or destination. Yeah, essentially. Also, there was a debate in my year of this exam of if EVs or electronic vehicles would fall under 437 because there's a debate if electronic vehicles would be it would be considered to be propelled by mechanism. In my opinion, I would say it would be because it has wheels, which are also conveyed by mechanism. But some people claims that they don't have motors and stuff like that. But I think, in my opinion, if you're going to answer the safest possible, I think you should say that it causes damage. Because when you claim that it caused damage, then you can analyze more in the exam. But if you claim that it cannot cause damage, then you can only analyze to that part and you would likely receive a lower score. So I would say if this part comes up and it's an EV vehicle, then you should say that it caused damage. I think it would be better. Section 438, this section essentially talks about liability, and it talks about liability of the person who has already committed a wrongful act. So it says that the court shall determine the manner and extent of compensation according to the circumstance and gravity of the wrongful act. Compensation may include restitution of the property which was the injured person has been wrongfully deprived, or its value, as well as damages for any injury caused. So this is more of a procedural part of the tort law. It's not really a part that deals with the tort itself. It essentially claims that if the court has already adjudged that someone is guilty of sections which is in tort or wrongful acts, then the court has the power to determine the manner and the extent of compensation. Compensation, when we talk about it traditionally, we would always think about money, or we would always think about things like, property. But a lot of times in these instances, especially when it's tort against someone's reputation, sometimes the court would order people to do like reputation damage control, or would make people like write apology letters on the mail or make a video to apologize or something like that. So there are other forms of compensation which the court may order apart from just monetary or financial compensation. Now, section 349, this section reads that a person who is bound to return a thing of which he has deprived another by a wrongful act is also responsible for the accidental destruction of the thing or for accidentally impossibility of returning it arising from any other course or for its accidental deterioration unless destruction or the impossibility of returning it um, would have happened even if the wrongful act has not been committed. Basically, in this section, it just says that a person who has been adjudged by the court to return a property has to return it in the quality which he has gotten it. So if you stole something, you have to return it in that quality. If there's deterioration, for example, if you stole something and you broke it or there was some damage to it, then you would have to compensate, which means that, for example, if I stole an iPhone and I broke it, then I would have to go buy a new iPhone for the person. But if, for example, this is a very old iPhone and it's not possible anymore, and it's impossible to find a new one or impossible to find a replacement of that specific item, I would have to pay for the accidental impossibility of returning it. So basically, this section just states that if I have to return something because of my wrongful act of committing a tort, I have to return in the quality that I stole it in or I took it in. If I return it in a quality which is poorer, then I will have to pay compensation or find a new one of the property to give it to the injured person. And if I could not find a new property of the same type to give it to the injured person, then in this case, I will have to compensate with money. There's a little caveat in this case, which is if it would have happened even if the wrongful act has not been committed. So this is talking about things like force majeure. For example, if I took someone's car, it's a wrongful act, right? Because I deprived someone of their property, and there was a massive earthquake that destroyed everything in the town, and the car would have been in the town anyways, and the car would have been destroyed anyways. In this case, then I would not be liable because it would have happened anyways. But if I took the car wrongfully and I drove it and I broke it or I sunk it, then in that case, then I would have to pay compensation for the wrongful act. So section 440, this is the last section I will cover. Unfortunately, we are kind of out of time. So this section reads that if on account of taking a thing, its value or an account of damage to a thing, its diminution in value is to be made good, the injured party may demand interest on the amount to be made good from the time which serves as a basis for the estimate of its value. Basically, this section states that when a thing is damaged, the value of the damage will be borne by the party who took it, but also the injured party could demand interest from the date when they were estimating the basis of that good. So, for example, if they already estimated that, okay, you have to pay me, for example, if someone stole my car, right? And it's already adjudged by the court that they stole my car and they have to return it back. But somehow they broke my car, so they can't return it and they have to give me money instead. From that day onwards, I can start demanding. So in this case, as the law has already stated, the default interest is 5% per year. So yeah, so you can demand 5% per year until they pay you back the full amount. Yes. So yeah, so this is the end of my part of the tort law session. I hope you all got more knowledge coming into this section. Does anyone have any questions? I will allow people to turn on their microphone. So if you have any questions, please open your microphone. You can just ask me. มีใครมีคำถามไหมครับ if you have any questions, you can just ask me, or you can just DM the CSP Instagram page if you have any questions relating to this subject or any other subject, and we will try our best to answer you. So ในนี้มีใครมีคำถามไหมครับ if not, then we will move on to public international law after the break. Okay,ครับ. So yeah, so let's take a 5-minute break and we'll see you back again at 5:45 for พี่เพลง and พี่ขวัญ public international law session. let me advertise them. They all scored very well, especially Pi Juan, which scored 99 out of 100 uh, in the exam. So yeah, so I think you'll get a lot of knowledge from both of them. Especially will help you with exam prep. So please stay tuned for that. Cup. Thank you very much for staying in my session, Cup. มึงสบายสบายแล้วเนี่ย
Hello everyone, welcome to Public International Law Session นะคะ Right now I'm playing พี่ and I'm gonna cover อาจารย์ Jarupapa part and พี่ขวัญ gonna cover อาจารย์ Thanapat part. Bear in mind that this subject is have a lot of content, so I think it will be impossible to cover all of them in a very detailed. So I'm gonna skip some of the information and you can dig deep into the drive of CSP that I will post it. Okay. First, Tanatchaporn part, it contains territory, statehood, and the use of force. In the territory part, the first one, the territory, the definition of it is an area of land under jurisdiction of the state. It's very important because it indicates the state right to prosecute crime committed within its boundary. So the determining of the territory is very important. And the component of the territory contain 3 elements. The first one is land territory, and the second one maritime, and the last one is airspaces. The first territory is the airspace. This one is not very confusing because it's just the air above the land and maritime territory that is governed by the Paris Convention and the Chicago Convention. And the next one, maritime territory, it is the territorial water. It contains a lot of the layer of the maritime, as you see in the slide that I post the picture. The first one is territorial water. This extends up to 12 nautical miles or mile in Thai from the baseline, and the state have almost full sovereignty for coastal state, and the only exception of the sovereignty is that the state must allow innocent passage for the foreign ship, and sovereignty in this territorial water include both airspace and seabed. The second one is contiguous zone, which extend to another 12 nautical miles beyond the territorial water, and in this area it had the limited control over custom, fiscal, immigration, and sanitary laws. And the last one, which is still very important, is the exclusive economic zone, which can extend up to 200 nautical miles. As you see in this picture, right here is the EEZ or exclusive economic zone. In this area, the state have the sovereign to control over economic resources such as fishing, mining, or oil, and there are no prohibition on rightful passage of other states. And the last one, land territory. This one, the territorial claim under land territory must contain 2 elements. The first one is discovery and allocation. At first, they have no man's land and the state that can acquire that no man's land can acquire that area. But right now, no man's land no longer exists. And in the past, state can use the execute that land. They have indigenous community, so it can still consider as no man's land. But right now, such claim is not cannot use. And the second one is effective control. A state must show de facto control. They cannot just use the excuse of mere discovery as demonstrated in the Clipperton Island and Island of Palmas cases. These 2 cases, in summary, the decision of this shaped the rule of the establishing territorial claim that the discovery alone is insufficient and the actual occupation of the state under that land is necessary for the claim of land. And the territorial claim also have exception. The exception of this is common heritage of mankind. The certain territory like deep sea bed, the moon, or the Antarctica cannot be claimed by any state as they are considered global resources under UNCLOS, the Moon Treaty, or Antarctic Treaty Protocol. And next, I'm gonna move to boundary delimitation, or we can like easily say that like the determination of the land, determining of the land. The first way to determine the land is vertical delimitation. Is quite simple. It covers a space of both land and maritime territory up to the edge of the space, and the aircraft or airspace of other state under this vertical delimitation have to receive the permission of the state from flying to that area. And the next, I'm gonna go to horizontal delimitation. This one is contain the land and extend to horizontal way. The way to claim the territory delimitation, the first one is agreement between states. The boundary can be determined by agreement between states, or if it cannot be determined, it can use the ICJ decision or arbitration. For example, like in Khao Pravihan case, it also decided by the ICJ that like this boundary, this territory is belong to Cambodia. And the next is the use of natural boundaries to determine the territory. This one, such as river, mountain range, and watershed line as reference point to determine the territory of the state. The advantage of this method is that it's easier to control and socially acceptable, but it is time consuming and may lead to the future dispute. For example, if the river has gone and there is a change of the natural boundaries, it may be lead to the future dispute. The next one is the latitude and the longitude. This method is used in the area that have no natural landmarks, such as desert or unmarked area. We can see in the African continent that most of them it is a desert, and we just draft the line to indicate the boundary of the territory. The pros of it is very easy to draw, but it can lead to absurd situation and may need to be redrawn later. For example, if the drawing line is like it separate the community or separate some races that are like that living there for a very long time, it may lead to the very problematic situation in the future. And for the maritime territory delimitation, we use UNCLOS or the United Convention of the Law of the Sea to indicate the territory, as we discussed earlier, that it I'm sorry. Okay, we indicate earlier in the slide that it contains like 12 miles and 24 miles from the seabed. Yeah. And the next one is the statehood. The next concept of the slide is statehood. It is the status of being a recognized independent person. The state is considered as an entity, so therefore the government action is considered the act of state. But there will be some exception. For example, private military company may differ, so they don't have some right as a statehood. And under international law, subject of law state were once solely subject, now other entities are included. And for example, right now UN are also considered as a state in some, not considered as a state, but can consider as an organization under international law. The importance of the state is that it creates the right of immunity and the right of ICJ access and some other right under the state. The example of this is Article 34(1) of ICJ statute. Only state appear in ICJ cases. The obligation of the state is that the state must respect the international law. Okay. Okay. Next, I'm gonna go to the criteria for being a state or criteria for statehood. The first one, the statehood must have permanent population, even though there is a they're not required to have the specific number of people. Some population may be scattered or migrate as long as they are stay within the state territory. For example, Western Sahara, in that for the people there, the people are migrating over and over within the land. Even though they are keep migrating, it's still considered as a population of the state because they are migrate within the land. And the population must be stable enough to exercise the function of the state. The next one is the defined territory. The state must have a clearly defined territory for the majority of it, even though precise boundaries are not always required. For example, Singapore may have more territory, may have more area because of the artificial land that they created, or some land have a dispute, but it does not negate statehood as long as mode of territory is established. And a state territory may split or change. For example, Bangladesh is split from Pakistan, or Alaska and Hawaii from the USA. The next one is the effective government. A state must have a government that can effectively control and administer its territory, ensuring protection for its population. And the government don't have to be sophisticated, but it must be able to maintain political control under the state. And the disruption or contest government can still lead to the recognition and still lead to the effective government if other state recognize that government. And the last one is that it is the capacity to relate with other states. A state must have ability to enter into diplomatic relation with other states, and recognition from other state is very important, because if other state don't recognize that state, they cannot have the relation within state, and it may lead to the lack of this element, and it cannot be considered as a state. For example, Transcade lack of relation with other state so they are not the state under this Article 1 of Montevideo Convention. However, state like Monaco, which let another state manage foreign relations, are still recognized as a state because they have capability to negotiate, to have a relation with other state, but they just voluntarily agree to let France to manage foreign relations, so it can also consider as a state, even though they don't have a relation with other state by themselves. And the state have right and duty under Montevideo Convention, as I make as a table from Article 2 to Article 9. The right of the state is that Article 2 state are one entity in international law, so they can have the relation and can do some act that belong as a state act. Article 3 is that state can act without needing recognition, as the state are already if they contain full element, as I said before, under Montevideo Convention, they are considered as a state and they don't need to get recognized by other states. And Article 4, states are equal in right and capacity. For example, no state have more right and more capacity than other states. For example, even though US is a very big country, have a very large economy scale, they have an equal right and capacity as a undeveloped country. And Article 5, state fundamental right cannot be changed by other. For duty of the state, Article 8, no interference in other state affair. It means that the state cannot interfere the other state affair in, for example, Thailand cannot interfere with other ASEAN country even though it affects Thailand. And Article 9, state must give the equal right for national and foreigner within the state. And other criteria for statehood that we will be discussed is recognition. It is the affirmation of other state to affirm the existence and legal status of a state under international law. And this recognition is not mandatory, but it is a discretion of the state to recognize the state existence. And this recognition, they often comes because of the political reason. For example, for Taiwan and China, they have so many complicated political reasons to choose between recognize China and recognize Taiwan. So it may not come from the genuinely will, but it comes from the political reason. And what is the importance of the recognition? As I said, under the element of the state, it does not contain the recognition, but the recognition confirms that the state gonna have the last element, which is the capacity to have a relation with other state. And Article 6 provide that recognition signify acceptance of legal personality of the state. And Article 7 said that recognition can be expressed by the legal writing or tactic, like the other political mean. And some of complicate political transition, it needs recognition of government. For example, Kazakhstan, not Kazakhstan, Afghanistan. New government recognition can affect the right and obligation of the former regime, and recognition can be used as a political tool with legal effect varying among states. And next we're gonna go to establishment of a new state. There are many ways to establish a new state. The first way is the cession. Cession is the transfer of territory and sovereignty from one state to another, typically following peace treaty. For example, England give Hong Kong to China, and the second one is the exercise of effective control, like demonstrate effective control over territory such as taxation and governments. The example of this is the Russia that already exercise effective control against Crimea of Ukraine, and the control must be continuous and legally recognized. The next one is self-determination. Self-determination is the expression of the population will to establish the new country and new state that separate from the existing one. Right now, it rarely happens in the modern time, but the example of this is the Timor-Leste that self-determination themselves to separate from Indonesia. And the next one is succession of states. A new state assumes the obligation of the former state, particularly regarding legal issues such as boundary and right. The example of this is Russia that after the Soviet was collapsed, Russia was exist and they also assume some of the obligation of former state. And the last one is Poompisit. It is the boundary that inherit from previous administrative division or the colonial border that it remained intact in the time of independence. The example of this is the is the European colonial boundary in Africa that after World War, the European removed the colony from Africa, and people from there can act under Poompisit to recognize there as the new state. The last one is the use of force. The use of force is the right to war. There is some, I'm gonna talk about historical evolution of this a little bit. At first, ancient time state has absolute right to use force, but next, in the 16th century, the just war doctrine emerged, and to use of force, it required just court for war. For example, for defend their right. And in 18th century, as it is the time of World War, the sovereign state had the right to declare war as a normal practice. But right now, under the development of the international law, it shifts to the use of force can be used only because of the self-defense. The rule regarding the use of force under the UN Charter, the very important one is Article 4 and 2.4 of the UN Charter, which is the prohibition of to use of force. The key principle of this is the state must refrain from the threat or use of force against the territorial integrity or political independence of any state. It is a customary international law, which means that even if the state is not a UN member, they have to allow to this law, to this article, that they cannot use of force against other territory. And the next one is the collective responsibility. Under Article 2.5, the states must assist in the UN in actions taken under the Charter and refrain from aiding states the UN is acting against. And under Article 2.6, non-UN states must act according to the UN's principles to maintain international peace and security. Key interpretation of this section, as you see, the key principle of this is the state is prohibited to use force against other state. The word use force can be categorized as four. The first one is wars of aggression, that this is the meaning of this is the state create a war that to aggress other state, which constitute a crime against peace, which is one of the most serious crime under international law. And the next one is prohibition of force to violate boundary. State cannot threaten or use force to other international border or settle disputes. Because of this reason, the act of the Russia to alter Crimea as one of the Russian territory won't be recognized by so many states in this world because it's under the prohibition of force to violate boundaries. And the next one is the state must refrain from act of reprisal. I put some table to show you the difference between retortion and reprisal. In this, the retortion means that the lawful but unfriendly act which does not contain the military force, for example, the sanction or diplomatic servants. This kind of unfriendly act has no limitation under international law, but reprisal, it is an illegal act taken in retaliation for period illegal act. For example, the state cannot use the military against other state. Next one, the prohibition of interference. The state must not organize, assist, or participate in civil strife of terrorism in another state. This one is the new area of law that happened after the Nicaragua case, that the state cannot help other state to commit the terrorism in the state. And the interpretation of force, it contains solely military force, and for economic or political pressure, it is considered not a force, but the intervention which is not restricted under international law. For example, nuclear weapons do not constitute force unless intended as a threat to territorial integrity, or to be easier, nuclear is not a force unless they are threatened to use against other states. And the next one is internal order. Even though the state is restricted to use force against the other state, but state can use force internally, for example, to manage riots, but must avoid escalating to a threat to international peace. And state right. Next one, I'm gonna move to state right to self-defense. This principle is established for a very long time, but right now I'm gonna talk about the Karen case. That is a very important case that established a basis for customary law on self-defense. The background of this is the first, like the US citizen assisted the rebels to the Karen ship in Canadian rebellion against the British. And after that, the British forces crossed US territory, destroyed the ship, and killed an American, and say that it constitutes a self-defense, and there has no limitation under this act. And this create the key principle of the customary international law under self-defense, that the self-defense to be valid, it must have first necessity, that the threat must be imminent and no peaceful alternative can be used. And the second one is proportionality. The response must not exceed to the threat. The UN has established the Article 51 of EU Charter to indicate the self-defense, the right under self-defense, that nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security. Measures taken by members in the exercise of this right of self-defense shall be immediately reported to the Security Council and shall not in any way affect the authority and responsibility of Security Council under the present Charter to take at any time such action as it deems necessary in order to maintain or restore international peace and security. The key that we get from the provision that the state have the right to self-defense when there is an armed attack, both individual or collective. And after the state commits self-defense, the state must report it to the Security Council as soon as possible, and the action must cease once the Security Council intervene and give the solution to that use of force against that country. Next, I'm gonna talk about Nicaragua case. The fact of this case is that the U.S. support the Contra, which is the rebellion, to overthrow the Nicaraguan government by sending a military force and assist in the fund to the rebellion. And they have an allegation of U.S. organized attack mining port and supplying rebels. The ruling of the ICJ is that the U.S. violate international law because they assist the rebel to intervene the Nicaraguan government. However, the court has clarified that only grave form of force constitute clear breaches of international law. For example, such as military force only, but supports opposing forces. For example, funding is not necessarily a breach of international law, but it's just discouraged. So what is armed attack? Under international law, it can be defined as the action that regular armed forces across border. And second, it is the act of sending armed group to carry out grave act resembling attack by regular forces. But there is an exception, is that assisting rebel with logistical or financially support does not amount to an armed attack, but may still violate the principle of non-intervention. And the development of the Nicaragua cases is that after the Nicaragua cases, the international law tried to expand the interpretation of an armed attack, not just the military force of the state, and it includes non-traditional acts such as bombing an embassy or terrorism like 9/11 incident that have been recognized as armed attack under SC resolution. And because of this resolution, it affirmed the right of the state to do a self-defense against terrorism. For example, U.S. invoked self-defense in Afghanistan, argue that Afghanistan provide bases and to terrorists amount to support for armed attack. And this one, preemptive or anticipatory self-defense. This is the last year take-home exam of this subject. It is the modern concept that is it is a threat like to use a advanced weapon with a rapid attack and with rapid attack capability challenge traditional interpretation of self-defense. And right now it is very controversy, but increasingly argue because right now they have very advanced technology like the nuclear or the long-range missile, and maybe the preemptive self-defense is necessary to protect the state territory. And the other criteria of state right to self-defense, the first one is necessity and proportionality. For the state to have the right to self-defense, first they must have necessity, that it must be imminent and it cannot be negotiated by the other means. And the next one is proportionality. The force of use, the force must be proportionate to the threat posed, considering the type of weapon and risk. For example, the threat to use the nuclear weapon, the nuclear weapon may still be justified if it is proportional. For example, if the state if the state is use the nuclear weapon, is attacked by the using of nuclear weapon, other state can be used the nuclear weapon because it is proportional. The next one is okay. The next one is self-determination. The self-determination was traditionally an internal matter, but under the new declaration, under the 1970 declaration, the state must refrain from using the force to deny people right to self-determination. So the third-party assistance for self-determination is controversial right now because under the declaration, the state cannot use force under the people who want to self-determine themselves. But some part it may be allowed on non-military matters. The last one is civil wars. The state generally prohibit from intervening in civil wars except for self-determination cases. And however, the legitimacy of the rebel can be recognized by the state. Okay, this is the end of the อาจารย์จารุปภา and next I'm gonna move to พี่ขวัญพัฒน์นะ
All right. Hello, everyone. My name is Kwan. I'm going to walk you through the second part, which is Ajahn Thanapat's part. We will cover 4 topics. First is the collective use of force. I put this as a first topic so that we can link it back to Ajahn Darupapa part. The second is the international human rights law, which I would not go in detail that much. The third one is state responsibility, and fourth is case study on the Rohingya genocide. In my opinion, I think the first and the third topic would be the most important that we should focus on. So let's get started. Okay, the first is the collective use of force. In terms of structure, I would start by recapping the use of force, and secondly, I will talk about more exceptions to the use of force, which are actions expressly authorized by the UNSC. Third, we will discuss the issue on whether the use of force would be lawful in case of humanitarian intervention and the implied UNSC authorization. And lastly, we will look at the Russia-Ukraine case study. Okay. To recap on the use of force, the prohibition on the use of force is in Article 2.4 of the UN Charter, which mandates that all UN members must not use threat or use of force against other members. And there is also the Nicaragua case that state that a third country sending help to another country that having armed conflict is also a threat to or use of force. And the prohibition of use of force is also a part of CIL. Now, in terms of exception, we have Article 51, right, of the UN Charter, which states that use of force can be accepted in case of self-defense. The first requirement is that there must be an armed attack, and second is that state use force to protect itself and immediately report to the UN Security Council. And in terms of lawful anticipatory self-defense, anticipatory self-defense would be lawful only if there were no armed attack by the attacking state yet, but that armed attack is imminent, meaning that it almost comes. And the responding state used force as a self-defense, and that use of force is necessary, proportionate, and not excessive, according to Caroline. And there is also the Nicaragua case, again, that provided third state sending logistical, supervisory, and financial support is not considered as armed attack. Okay, now turning to more exceptions to the use of force, which are the actions expressly authorized by the UNSC. There are a couple of UN Charter articles that I would like you to remember, which are the one in the slide. The first one is the Article 24 of the UN Charter, which states the UNSC duty to maintain the international peace and security, including by use of force. It means that in some necessary case, UNSC may use force or authorize states to use force to maintain peace. In Article 39, it gives the UNSC power to make recommendations or decide what measures under Article 41 and 42 should be taken. Article 40 gives the UNSC the power to issue a provisional measure while making the decision under Article 39 to prevent an aggravation of the situation. So this means that the UNSC would make some recommendation when there is when some state is perhaps violating international law. It may like starting war or something. So, but when the UNSC make recommendation under Article 5, it takes time. It may take months. So it may issue provisional measures, which is like มาตรการชั่วคราว under Article 40, meanwhile, while it making decision. Now, Article 41 gives the UNSC the power to call upon UN member to take measures not involving the use of armed force. Okay, this one is not about using of armed force, but UNSC can also like allow UN member to use other measures such as the interruption of economic relation or stopping the diplomatic relations with the country that is starting war or is breaching international law. And lastly, and the most important, is the Article 42, which is about collective use of force. UNSC has the power under this article to authorize UN member to take measures involving use of armed force, such as the operation by air force, sea force, and land force of the member states. An example of the use of Article 42 is the invasion of Kuwait case, in which Iraq invaded Kuwait, and the UNSC look at this situation and it make recommendation under Article 42 that allowing state to use its armed force against Iraq. So in that case, 29 states participate in this collective use of force, which is again lawful because it was authorized. Now, moving to the next point, which is that whether the use of force is lawful in case of humanitarian intervention and implied UNSC authorization. Humanitarian intervention means when one state intervene into another state domestic matters with reasons related to humanitarian or มนุษยธรรม นะคะ To give an example, I would say that if country A saw country B commit genocide to its own people within its country, country A say that, oh, this is humanitarian matter, I would invade, I would like send my armed force to stop them, something like that. So whether this is lawful or not, Article 27 of the UN Charter says that state cannot intervene in other states' domestic affairs. So the answer is that it's unlawful unless it is done with the UNSC authorization. Next, the implied UNSC authorization. Implied UNSC authorization is, for example, UNSC condemns an illegal activity in one state and demanding that state to stop, but it does not expressly authorize other UN members to do anything. So, like, for example, UNSC may see like state A doing genocide or whatever, and it issues a resolution or mati that, oh, your act is really bad, you should stop. The answer is that this to like use of force against another country based on implied authorization like this is unlawful, and it has never been recognized in international law. For example, there is the NATO's intervention in Kosovo and the US-UK invasion of Iraq. In both cases, their intervention are unlawful and cannot be justified based on implied authorization. Now, last topic for the collective use of force, we have Russia-Ukraine case. So a little bit of the fact is that Russia used armed force against Ukraine, right? Which is against Article 2.4. This means that Ukraine has the right to self-defense under Article 51. The UNSC cannot do anything in this case to maintain international peace because Russia have a veto vote in the UNSC because it's like one of the 5 permanent members of the UNSC, right? And each permanent members have a veto vote, which means that if one of them don't agree with something, a resolution cannot be passed to like tell Russia that you should stop. So the UNGA, which is another like organ within the UN regime, which has like the member are all UN members. The UNGA adopt a resolution instead to reject Russia's action. There are 143 votes agreeing with the UNGA. However, Thailand abstained from voting. In 2022, Ukraine filed a claim against Russia to the ICJ under the Genocide Convention, which ICJ has compulsory jurisdiction for both states. However, Russia rejects ICJ jurisdiction. Now, in this year, right, 2024, 32 states declare intervention in favor of Ukraine. So like basically like many states such as Spain would like submit intervention into the ICJ to say that, okay, we back Ukraine. And the most recent update on February this year is that ICJ has jurisdiction. Okay, turning to the second topic, which is international human rights law. Again, I would not go in detail. Like if you're interested to go in detail, you may read the slide that I make or refer to like the notes from CSP. For this topic, I would talk about the key agreements and the UN's human rights mechanisms. Okay, so the key agreements are here. There is one customary international law instrument, which is the UDHR, Universal Declaration of Human Rights. And then there are also 9 core human rights treaties, such as the ICCPR, ICESCR, and so on. As you can see, the one in the top that are in blue are more on the general side. It covers many issues about human rights in general, while the one below in pink were more specific. And side note, Thailand is party to all treaties and all treaties except number 9. Okay, in this page, we have the UDHR, which has a status of customary international law. First part, it covers the spirit of the UDHR, which is that all humans are born with inherent and equal value. And Article 2, which is that non-discrimination. And the next part covers the civil and political rights. And the third part covers the economic, social, and cultural rights. Now, in this page, we have the International Covenant on Civil and Political Rights, or ICCPR, which has the status of treaty, and it was separated into 5 parts, including the right to self-determination, the state's obligation to respect individuals' rights, the civil and political rights, the establishment of an organ which is called Human Rights Commission, and lastly, the obligation to not interpret the ICCPR to conflict with other laws. Then we have the International Covenant on Economic, Social, and Cultural Rights, or the ICESCR, which has the status of the treaty. There are also 5 parts which are similar to the ICCPR. So yeah, for the interest of time, I would skip it. Now, in this page, we have the Convention on the Elimination of All Forms of Discrimination Against Women. So yeah, as the name suggests, it focuses on the equality between men and women in like political life, employment, under the law, and also prohibits trafficking and sexual exploitation. The next is the Convention on the Right of the Child. It has four basic principles such as the non-discrimination, all action must take into account best interest of the children, right to life, mental, social, and lastly, right of the child to express opinions. The next is the Convention on Elimination of All Forms of Racial Discrimination. As the name suggests, it prohibits racial discrimination, and it also imposes obligation on state to eliminate all forms of discrimination and guarantee the equality. The next one is the Convention Against Torture. So it focuses specifically on the act of person acting in state officials' capacity not to like torture people to get information or as a punishment. Next one, the Convention on the Right of Persons with Disability. It guarantees the right and freedom of disabled person. The next one is the International Convention on the Protection of All Persons from Enforced Disappearance. So it prohibits the enforced disappearance, and it also impose obligations on state to investigate and prosecute who violate this law. And lastly, we have the Convention on the Protection of the Rights of Migrants, Workers, and members of their families, which Thailand is not member of this one. This one, I would like to highlight that it covers the right of both legal and illegal migrant workers. Okay, now we're gonna look at the UN's human rights mechanisms. There are three types of mechanism. First is that the mechanism that is provided within the UN Charter. Second, other mechanism within the UN regime but outside of the UN Charter. And lastly, the mechanisms from the NGOs. Okay, in terms of mechanisms within the UN Charter, we have four main like organs or organizations within the UN Charter. The first one is UN General Assembly or UNGA. The members are all UN members, and it works by issue resolution recommending on human rights matters, which is not binding. Next is the UN Security Council or the UNSC. As I told you a little bit earlier, that there are 5 permanent members, including the US, the UK, France, China, and Russia, and 10 other non-permanent members, which kind of rotate every now and then. The role is similar to UNGA, but their resolution would be more coercive, and they have the power to authorize use of force. Next, the UN Economic and Social Council. There are 54 members elected by the UNGA, and it would receive complaints about human rights violations and coordinate with specific agencies like International Labour Organization, World Health Organization. And lastly, we have the UN Human Rights Council, which has the role to monitor and stop human rights violation and also help states to do that. Okay, in terms of other mechanisms outside of the UN Charter, we have special human rights treaty mechanism within the UN regime, including like the ICCPR, the ICESCR. This would be mechanism provided specifically within the treaty. For example, the ICCPR would provide mechanisms specifically for civil and political rights. The CAT would provide mechanism specifically related to torture. Next is the spatial human rights mechanisms, which is often in the form of spatial rapporteur who would do fact-finding and make reports on human rights. And lastly, the UN High Commissioner for Human Rights, which also has the role to promote international coordination in terms of human rights. Lastly, we have the NGO roles. So from time to time, the UN would ask for the advisory opinion from NGOs, and the degree of each NGO's role would depend on its nature and its expertise. Okay, so we're done with the second topic. Now let's move to state responsibility. Let me drink a water. Okay, in terms of state responsibility, we have three parts. I would go through the overview, then the rules on state responsibility, and the defense for state responsibility. Okay. In terms of overview, what is state responsibility? In my words, I would say that first, there is an international legal obligation enforced between two states. Second, a state's act or omission violates that obligation. Oh, sorry, reparation is a typo, sorry. And third, that act or omission resulting in a loss or damage of another state. If three requirements are satisfied, this gives right to a state responsibility and thus a duty to make reparation. The main legal instrument that I would like you to remember is the ILC Articles on State Responsibility, or ASR, which, if I get it correctly, is the reflection of customary international law. Okay, under the ASR, first, there must be a fault under Article 2, which this means that an act or omission of a state breached its international obligation. We have one case to exemplify this, which is the Nia case. What happened in this case was that the US person was killed by a normal private person in Mexico. So it was established by the court that no fault of Mexico was found because the injured party failed to prove that the state omit its duty to serve justice by prosecuting the killer. So basically, if it can prove the omission, there would be breach of international obligation, but it could not prove. The second requirement is that the fault must be attributable to the state, or in Thai I would say that ความผิดที่เกิดขึ้นต้องโทษ state ได้ under Article 2 as well. This means that there must be a linkage between the act that caused injury, right, and the state. The Corfu Channel case, okay, in this case, what happened is that a British ship passed by an Albanian water and it got damaged by a mine explosion. So this damage is attributable to the Albanian government because it has the duty to warn the British, but it omits to do this duty. Now, in terms of attributability, there are two sub-points that I would like you to remember. The first one is that the state officials act is attributable to the state. Under Article 7, acts of person, state official acts means acts of person acting in official capacity or authorized by state. And this is attributable to state even if the action is ultra-virus. Ultra-virus means the act is beyond the legal or authorized capacity of that person. For example, in Claire's case, the Mexican soldier tried to extort money from French person by taking him to military base and murdering him. This fault is attributable to Mexico. So you can see that this is apparently ultra-virus, is beyond the capacity of a soldier, but since it's an act of a state official, it's attributable to the state of Mexico. Therefore, Mexico has state responsibility. Now, the second point that you should remember is that the act of a private person under official control is also attributable to the state under Article 8. This refers to the act of a person done under instruction, direction, or control of the state or state officials. For example, I would say that you randomly walking in the street, right? And there is a foreigner person running from a police, and police yell to you that, oh, please help catch the thief. So you catch him and you injure him, and turn out that he is not a thief or something. And even though your action is a private person action, but it's done under the instruction of a police, which is state official. Therefore, this fault is attributable to Thailand. Okay, we done with the rule on responsibility. Now we look at the exceptions. There are 3 main defense under the ASR that you should know. The first one is the force majeure defense under Article 23. The requirements are: first, there must be an irresistible force or an unforeseen event. Second, that event must be beyond the control of the state. Third, it is impossible to comply with international law obligation. And fourth, the force majeure situation is not due to the state's fault. And fifth, the state cannot assume, like it cannot expect the risk of that situation. An example of this is the Rainbow Warrior case. It's the name of the ship, by the way. So the French ship named Rainbow Warrior sank in the New Zealand water. So and two French officer was in there. France and New Zealand then make a treaty agreeing that the 2 officers will be held in New Zealand military base. Eventually, they were sent back to France due to like medical reason, which was justified. But later they disappear and like never sent back to the military base as agreed. So the result is that France breached the treaty and cannot claim force majeure. Like they cannot claim that it is force majeure that the two officers run away, because it kind of able to prevent it. Therefore, France has state responsibility under the ASR. Okay. Now, the second defense, distress under Article 24. There are 5 requirements. First, there must be a threat to life of a specific person, a particular person. Second, there must be a spatial relationship between the state organ and that person in question. Like it must be an exceptional situation where if a state doesn't act, it will have very much effect on that person. Third, there is no other reasonable way other than to breach international law. Fourth, state did not contribute to that situation, so it must not be the state's fault. And lastly, measures was proportionate. The last defense is necessity under Article 25. There are 6 requirements. First, the action that breached the international law must be the only way. Second is the only way to safeguard an essential interest against a grave and imminent peril. Fourth, it must not seriously impair an essential interest of the state. Fifth, the situation of necessity is not due to state fault. Again, it must not be state fault. And lastly, it must not be the violation of international law that particularly does not allow the invocation of necessity. So I would say that some particular international law does not allow you to to defense that you did it out of necessity, for example, genocide. Now we have one example, which is this case, which I have no idea how to pronounce. In this case, what happened was that Hungary has an international obligation to build a dam, เขื่อน, but it stopped the project, and it claimed that it stopped because of the necessity, because building the dam will harm the environment. The court decided that this is not necessary because Hungary did not provide a sufficient proof. Therefore, it has state responsibility. Okay, we're done with the 3 exceptions. I would say that the one that is most easy to prove is the force majeure, the first one. And if you see this in the exam, I think there is no right or wrong in interpreting each requirement. I suggest that you should remember each requirement and try to apply them in your own way because they are very subjective, but just also refer to the case would help as well, I think. Okay, and now we're moving to the last topic, which is the case study on Rohingya genocide by Myanmar. Okay, I will talk about the fact and then the ICJ proceedings and then Myanmar's arguments. Okay, the fact in this case was that Rohingya is a Muslim community in Myanmar territory. In 2016, Myanmar committed a genocide to destroy the Rohingya community. There were killings, rapings, and other sexual violence. In 2019, the Gambia, which is a Muslim country, on behalf of Rohingya as a Muslim community, filed the case against Myanmar before the ICJ. Okay, now we're gonna look at the ICJ proceedings. So ICJ issued a provisional measure before the judgment. Provisional measures is like มาตรการชั่วคราว so you know in order for ICJ to issue a judgment, it takes like months or even years. So ICJ must order something to like stop Myanmar from killing. So it stopped Myanmar by issuing a provisional measure. So this provisional measure ordering Myanmar to stop all acts of genocide and prohibit Myanmar from destroying the evidence relating to the genocides. But do you think Myanmar comply with that provisional measure? No. So now we're gonna look at U.S. domestic court proceedings. In 2020, Gambia requests the U.S. court to order Facebook. So it has to go to U.S. court because it wants to order Facebook to disclose information about Myanmar officials' posts. In those posts, the Myanmar officials spread news about that Rohingya are terrorists or something, which are fake news. The reason that it had to request Facebook in the first place because Myanmar tried to delete those evidence as much as possible. As I told you that it doesn't comply with the provisional measure to not destroy the evidence. And eventually the U.S. court upheld the Gambia's request so it can access to those evidence. Now back to the ICJ proceedings. We're gonna look at some of Myanmar arguments that try to say that, the Gambia has no power to sue or the ICJ lacks jurisdiction. The first one, Myanmar argued that the ICJ lacks jurisdiction because the plaintiff should be the organization of the Islamic Corporation, not the Gambia, because like it kind of sue on behalf of the whole Islam community, right? The second argument, Myanmar says that the Gambia lacks power to sue because the genocide happened outside of the Gambia to non-Gambian citizens. Third, Myanmar claims that the ICJ lacks jurisdiction because of Myanmar's reservation under the Genocide Convention. So, like Myanmar does not accept ICJ jurisdiction under this convention. And lastly, Myanmar claims that the ICJ lacks jurisdiction because there was no dispute between the Gambia and Myanmar. And the result was that all arguments of Myanmar are failed. Typo again, sorry. Failed, not filed. So, therefore, the ICJ has jurisdiction. Now, I'm gonna tell you the reason why each argument failed. Okay, the first argument that the plaintiff should not be Gambia is failed because Gambia is a state. So, according to the ICJ statute, it can be a plaintiff. The second argument was failed because, like, even though genocide did not happen in Gambia or happen to Gambian people, it's a crime against humanity. Like, the special thing about genocide is that it violates the most basic and fundamental principle of international law. It is so inherently important that, like, when you commit genocide, you don't just commit crime to that particular group of people, but to like all humans around the world. Therefore, Gambia have power to sue. The third argument that ICJ does not have jurisdiction because Myanmar's reservation is failed because the issue before the court is not actually just under the Genocide Convention, but also the interpretation of genocide, which is a part of CIL. And basically, you cannot reserve from CIL. And lastly, the fourth argument that there was no dispute between Gambia and Myanmar failed because there is actually a dispute, which is the issue on the interpretation of genocide. Therefore, since all arguments are failed, the ICJ has jurisdiction. This actually ends my part and all of the sessions. So, since we still have time, feel free to like open the mic to ask question, or you can type the question in the chat. Did you raise your hand?
สไลด์จะอัปโหลดในช่องทางไหนไหมเหรอคะ
อะไรนะครับ
สไลด์อัปโหลด
เดี๋ยวสไลด์จะอัปโหลดไปใน Drive แล้วเดี๋ยวลิงก์จะแจ้งไปในเพจของ CSP นะครับก็สามารถตามเพจได้เลยครับ
ขอบคุณค่ะ
มีใครมีคำถามอะไรอีกไหมครับถ้าไม่มีก็ขอบคุณทุกคนมากๆนะครับที่มาขอให้ทุกคนได้อะไรจากเลสชั่นนี้แล้วก็ขอให้ทุกคนสอบผ่านครับขอบคุณครับ
ค่ะขอให้ทุกคนได้คะแนนดีทุกวิชาขอบคุณมากแล้วก็ถ้าใครมีคำถามก็ถามมาในโซเชียลมีเดียของ CSP ได้
ขอบคุณครับ
ขอบคุณค่ะ ขอบคุณค่ะ
ขอบคุณครับ
ขออยู่ก่อน